Let's get a bit more on the legal ins and outs now with Eric Lisann, a lawyer and legal expert, joining us live from Washington. And Eric, does this mean the Supreme Court is satisfied that Trump's ban does not relate to the religion of those people affected? Because that is what was a major concern for judges in the smaller states, wasn't it, in the smaller courts?
Right. Very good question, Laura. And it does not technically or legally mean that, because we're still at the phase which is called a preliminary injunction, where we haven't had the so-called full-blown trial on the merits. However, what could make the president and his team very happy is the concurring or partially dissenting opinion of 3 judges to what's called a per curiam, like an unsigned order. And those 3 judges include the brand new Justice Gorsuch, along with Justice Thomas, who actually authored it, and Justice Alito. The 3 of them say, look, we would knock out the stay and reinstitute the ban according to the way the president wants it for everyone. We just think it's going to go that way on the merits. So what they're saying is, at least for those 3, those are probably the 3 most right-wing members now. Gorsuch is probably going to be the most on the right. They are supporting the president's position on this. They're probably not going to want to look at all of the president's extraneous or extrajudicial statements that he made on the campaign trail or while he was president. They're just going to look at the text of the ban, and if they can give the president the benefit of the doubt and say it's facially neutral, those 3 will probably rule his way in October. It doesn't address the question of the other 6. The other 6 in the main part of the opinion didn't get into any of that. So we'll have to see what happens when the Supreme Court actually takes up the full case properly at the resumption of their term in the fall.
And of course, for those that don't know, Neil Gorsuch is the Supreme Court justice who was appointed by President Donald Trump. Nominated by President Trump. That brings me neatly onto my next question, then, Eric. Just on comments by the Attorney General Jeff Sessions just a short while ago, he says that this ruling is an important step toward restoring the separation of powers between the branches of the federal government and the president's right to protect national security. What do you make of that?
Well, that's always been the principal hook that the administration has used, the principal legal theory to defend what it's been doing, because they've been telling the courts, in essence, you can't review what we're doing here because this has to do with national security, this has to do with foreign affairs, this has to do with immigration. So not only does it come within very important core areas of executive power, but there's even a congressional statute which delegated to us, the executive branch, the ability to do that. However, there are limits, and the lower courts have already found that those limits have been exceeded, not only by the fact that the president's statements for all of those judges who considered it indicated a discriminatory and therefore illegal intent, but also in terms of the action not really being well suited to its purpose. And so that's something that the Supreme Court will have to look at. How much leeway do they give the executive branch in fashioning these kinds of policies? If it's completely nonsensical, but otherwise non-discriminatory, for example, could it be nonetheless allowed? That's one of the things that will be briefed and argued in the fall before the Supreme Court.
Eric, thank you very much indeed for explaining all of that to us. Eric Lisann there in Washington.